Good morning. Welcome back. Be seated, please. Give me just 1 minute to pull the file out. Let's see. We are here on HERON Gutierrez versus C&C Pumping. So, whenever you're ready, we may proceed.
May it please the Court?
Good morning.
Good morning, Your Honor. My name is Catherine Anderson on behalf of the plaintiff, appellant HERON Gutierrez. May I reserve 3 minutes for rebuttal?
Yes, ma'am.
Okay. All right, Your Honor, this is a personal injury action in which Mr. Gutierrez was injured on a construction site back in September of 2006. He was working, holding onto a boom that came out of a concrete boom truck that was owned by the appellee. As he was doing that, he was about 55 yards away or so from the gentleman that was operating the concrete truck, and that was Chris Holdorf. In pouring the concrete, well, let me back up before I get to that.
I think we're familiar with the facts of the case. Let me ask you, as it relates to the motion, you filed a motion for protective order and/or a continuance of the summary judgment hearing.
Yes.
And one of the bases of that was, there was pending discovery. But when I look at the file, I don't see that there were any depositions scheduled. I see the emails that there was some talk about, can we depose so-and-so, but I don't see any outstanding discovery requests for admissions, etc. Is that correct or incorrect?
That is correct. There were depositions that were in the process of being coordinated between the two party attorneys in the case. Mr. Panagakis was on a trial docket, and the case was also complicated by the fact that one of the defendants filed bankruptcy, so the whole case was stayed for over a year.
And I see that the lawsuit was filed in June of 2008.
Yes.
We lose a year because of the bankruptcy, but the summary judgment motion wasn't until April of 2011. So,
yes.
It's not exactly this thing didn't exactly speed through. There was a fair amount of time that went through for discovery to take place. Help me with one other, just to make sure that I understand the procedural posture of the case.
Okay.
It looks to me like that the judge entered his order denying your motion for continuance after he had in fact ruled on the summary judgment motion. Yeah,
the hearing actually took place probably within a week or so of the actual motion for summary judgment. I can give you the dates. The hearing on the motion for protective order was on April 12th, and then the hearing on the motion for summary judgment was May 2nd. For whatever reason, by lag between the attorneys getting the orders agreed to, I'm not exactly sure what the delay was, but it didn't make its way into the court file until after.
He had already heard the motion.
Yes, Your Honor.
Okay, so I just couldn't understand the timing because it looked like maybe he was just cleaning up the file, but he did hear your motion for continuance.
Yes.
Prior to, and presumably, if it's fair to imply anyway that whether he ruled or not, the fact that he went ahead with a summary judgment motion, I think is indicative of the fact he wasn't inclined to give you a continuance.
That's correct.
Okay, I was just trying to clarify that timing.
And this is, a complex case. The depositions in this case that had
related to that same thing. It appears to me at the end of the hearing, where on the motion to continue, where things were left was that the defendant was going to agree to reset the summary judgment hearing if you would agree to continue the trial date. Is that accurate?
That's my understanding, yes.
Okay, and then the next thing we see in the record is that you're filing a lengthy affidavit in opposition to summary judgment and you go forward.
Right, because
with the hearing.
The hearing was unilaterally set, it wasn't coordinated, and we went ahead and filed
we knew all that at the time of the motion to continue.
Right.
and the fact that there seemed to be an agreement as to how to resolve that, and then it appears from the record as if your client or the attorneys below elected to go forward with the summary judgment hearing rather than continue the trial.
Yeah, I think it was based on the prior order from Judge Rodriguez denying the motion for protective order and or the motion for continuance. The issue on the motion for summary judgment going forward is evidently the parties were not able to agree to either take the case off the docket. My understanding is that the defense attorney would not agree to reschedule the hearing on the motion for summary judgment after he agreed to do so. So that's why it proceeded as planned.
My next question is, under Rule 1.510F, in order to continue a summary judgment hearing, you have to file an affidavit explaining what specific discovery you need, why you need it to oppose it, and what efforts you've made to secure that discovery, and that it wasn't because of lack of diligence that you couldn't get that done before the summary judgment motion was set. And that wasn't done here, is that correct?
That is correct. The only affidavit that was filed was the expansive 200-page affidavit by by Farhad Bouassagi, who is our expert in the case, outlining the 5 points in which he felt that the defendant was grossly negligent in this case.
So based on the failure to follow the rule and secure a continuance of the hearing on summary judgment in an appropriate way under the rules, and based on the fact that you were able to get this expansive affidavit of your expert who opined that he had sufficient evidence on which to base his opinions, can you really say that the court erred in denying the motion to continue and postpone the summary judgment hearing?
Yes, Your Honor. There was a hearing, on the motion for protective order, on the motion for continuance. It was unfortunately one of those ex parte hearings. It kind of sped through. Mr. Panagakis didn't get an opportunity to fully elaborate all of the grounds in which he needed to have the motion for summary judgment pushed back, but the basis of it was the fact that these depositions, the parties had already agreed to take all of these depositions, and they didn't get scheduled.
Well, maybe I'm a little bit leaning one way as a trial judge day to day and week to week, but if people can just come into my court and say, we want to continue these summary judgment hearings, we have some discovery still to take, or even some depositions scheduled, but they can't show me how it pertains to, a statute of limitations, which is what I have, the discrete issue for summary judgment, or whatever the issue is.
Right.
And they don't follow the rules. You think that that trial judge should be overturned then for not granting the continuance?
Yes, because the overwhelming presumption in the state of Florida is to have trials heard on their merits, and cases heard on their merits, and they shouldn't be dismissed based on technicalities,
right,
even if the rule does require it. And we've cited several cases in our brief. I can go over them with you, but I'm sure you're familiar with that.
Well, he didn't dismiss on a technicality. He simply said, I'm going to deny your continuance. And
yes,
when you didn't follow the rules to get the continuance, even marginally, but you still think that would be reversible error just because of the general preference for deciding cases on the merits?
Yes, Your Honor.
Okay.
Yes. So
on the substantive issue, in your brief, it's a little, and below, it's a little confusing. You lay it out and say that the exception that we're traveling under is the intentional tort exception in 440.11.1b, and then you quote that statute. You never alleged that below. You never alleged an intentional tort below, and then you immediately start talking about gross negligence, which is not the standard for the intentional tort exception.
Right.
You want to clarify?
If you look at the statute, and I think we have it quoted on, if I can guide you to that, page 8 of our initial brief, it talks about it's an either-or situation. And it talks about the intentional act, but that also goes to whether or not the employer was grossly negligent. The statute itself is fairly new. It hasn't been really subject to any type of interpretation as of this date, but the issue in this case is not an intentional tort. The issue is whether or not...
Yeah, I mean, I think you're right. It's not an intentional tort. I'm just wondering why you said that it was and quoted that statute.
Yeah, definitely not an intentional tort that we are alleging in this particular case. It's gross negligence. And there's a distinction between simple negligence and gross negligence in the case.
You're really traveling under the horizontal immunity exception in 440.10(1)(e),
yes.
aren't you? Okay.
Yes.
And so the intentional tort exception has nothing to do with this case.
No. If you look to there is one case.
It was just cited and quoted mistakenly, I guess, maybe?
Must have, yeah.
Okay.
I must have, Your Honor, my mistake.
Okay.
I apologize.
I guess my next question is, if you're traveling under that exception, which does deal with gross negligence, why wouldn't you look to cases that interpret the fellow employee immunity, which also is a gross negligence standard? Why wouldn't you look to gross negligence as interpreted relating to the same statute? You say we shouldn't look at those cases, basically, because that's a different subsection, but it is the same statute. They're both immunity provisions and exceptions to workers' comp immunity.
We did cite some of those cases,
Okay.
and I can just go to my notes here real quick. You're talking about the co-employee?
Right.
Okay. That wasn't the situation here. Okay. Chris Holdorf, I'm sorry.
I know, but the co-employee exception and the horizontal immunity exception both have gross negligence standards.
Right.
And I'm wondering why, would you agree that you would look to those cases that interpret gross negligence in
Yes.
both contexts? Okay.
Yes,
Okay.
and I believe we did so in our brief. Okay. The second issue, moving on to the second issue, outside of the motion for summary judgment, we felt that was entered prematurely based on the fact that this affidavit was filed that was over 200 pages, set forth 5 areas in which the defendant was grossly negligent. We also are of the opinion that the trial court erred in entering summary judgment based on the fact that the discovery had not yet been completed in this case, and we kind of went through that already. There were several depositions that had been taken place, that had took place already. The plaintiff, Jim Swan, who was actually in Mississippi at the time, we took his deposition. There were several other depositions that took place, but unfortunately, due to the complex nature of this matter, there were several other cases that several other depositions that needed to be taken.
Somewhere in this expansive affidavit of your expert, Dr. Bushagi, if he did, I missed it, did he say, I really need this additional information that might come from this employee or from this other employee whose deposition hasn't been taken yet, but is scheduled? Is there any indication in his affidavit or in any other affidavit that
No.
any of this discovery you're talking about would have really accomplished anything insofar as the summary judgment?
No, the purpose of the affidavit was to rebut the motion for summary judgment, and he based his affidavit on all of the findings that he had up until that point.
So apparently he needed no more information, factually.
Well, that's not to say there wouldn't be other issues that came up that needed to be addressed. And, Mr. Gutierrez has the right to, pursue all of that and have all of those depositions taken so all the facts are set forth in order to preclude a motion for summary
Well, I'll
judgment.
try to be quiet here in a moment and let you go on, but I did have one other question about
Yes.
Dr. Bushagi. He states in paragraph, I think it's paragraph 13 of his expansive affidavit, somewhere in a paragraph number 13, I have a note, that Chris Holdorf knew or should have known that the soil density records found the grounds unstable at various locations, and at some other part he puts, let's focus on this, that Mr. Holdorf, quote, knew that his actions would probably most likely result in injury to HERON Gutierrez, close
Yes.
quote. Can you point to any evidence in the record which would support an opinion that Mr. Holdorf actually knew that his actions would probably most likely result in injury?
Well, first of all, he should have brought his own cribbage and dunnage to the work site that day. He didn't do that. He relied on other people to bring it to him. If you look at the manual, the swing manual, he was supposed to bring a certain type of wood to secure the bottom part. He didn't do that. He took a lot of careless steps in dealing with this big, huge, giant cement truck. He relied on the soil density tests completed by the general.
That sounds like regular negligence, but I mean, is there the fact that you use somebody else's cribbage, that there's nothing about that, for example, that would indicate to me that I therefore know that something is about to happen that's going to hurt this person, that you have knowledge that this is likely to cause
Well, there was
injury.
knowledge that the soil was unstable in the area. And
Where is that in the record?
It's in the soil density test and in the testimony by Sergio Gutierrez.
Well, I think all of that points up to, he should have known, that you could argue that at least. I understand that argument.
Yes.
But I'm trying to find out on what basis someone could say he knew. I mean, did he admit it? Is there any other
No, he denied it.
testimony or evidence that he actually knew that he was about to injure someone?
I think
Most
the
likely?
issue is he should have known, reasonably should have known.
So you won't point to any evidence supporting your expert's contention or opinion that he knew?
He knew based on the fact that he didn't bring the correct materials to the work site. He didn't check the soil density tests. He was standing 160 yards away from Mr. Gutierrez, who had his back turned to him. All of that points to gross negligence. All of that points to the fact that this is not his first rodeo. He's been doing this for several years, and he should know that this is a dangerous, dangerous act. And by the way, this was at night. This was at 1 o'clock in the morning when this all started. So there's also issues of lighting. And in Florida you have, in September, which is when this accident happened, we're still in the afternoon rainy season where you've got, rain and so on and so forth that may happen on a day-to-day basis. So all of those things taken into consideration, he knew.
Let me ask you this. Do you think that Hoyt versus Corbett, you cite the case and say but that case went to trial, but it sets forth what needs to be established to establish gross negligence in this context, that the circumstances indicate an immediate, clear, and present danger amounting to more than normal and usual peril. I mean, the three criteria. Do you agree with the law as set forth in that case?
Well, the issue in that case, as you pointed out, was...
No, I'm asking about the legal elements of gross negligence in this context. Do you believe that accurately reflects the law?
No, I don't. I think if you could look to some of the other cases that we cited with respect to gross negligence, and you have to go all the way back to, the 1970 cases where they actually define the difference between gross negligence and simple negligence. And you have to go back to...
You think we should conflict with Hoyt and the other cases that construe gross negligence more narrowly when it comes to workers' comp immunity than some of the other cases discussing gross negligence generally?
Yes.
Ms. Anderson, you've got about 2.5 minutes.
Okay. I'll reserve then. Thank you.
Your Honor, Richard Sherman for the appellee and James Sherman for the appellee. The facts were clearly laid out, and it's doubtful this may not even be simple negligence, much less gross negligence. It was an underground cavity that collapsed. The GC, as required by law, had done soil compaction testing on the whole site, which had passed the city and county inspections. Heavy equipment was driven across the area every day. Our guy, when we came to the job site, the GC told us where to set up. I mean, we didn't know where we were going to set up on any given day.
What about the requirement or suggestion in the Schwing manual, apparently, that the operator, I forget what the name of the test is, but he's supposed to bring something with him so he can test the ground where he's about to put down the appendages under which the dunnage go?
Well, manuals are not evidence of negligence. I mean, there are, as you know, in your car manual, everything else, if you did everything in there, you'd never get the car started. It was done by the GC, the standard in the industry. I mean, he never knows where he's going to set up, and he had pumped on this exact site 4 times previously with no problems. You know, instead of just using the 3-inch wood pads under the outrigger pads, he did the additional precaution of putting 8 4x4s under the outrigger pads to spread it even more. He then circulated the boom to make sure, you know, if he heard any cracking wood, he would know that it was a problem, and there wasn't any, and he pumped for 35 or 40 minutes before this accident happened. So I think the evidence is clear that it's doubtful there's even simple negligence, but there certainly was no gross negligence. There was no reasonable way anybody could have known.
Mr. Sherman, if you put that pen down, you might quit clicking it every second.
I'm sorry?
I don't think
I'm sorry.
I don't think you realize that you're clicking that pen every second.
I'm sorry, Your Honor. I didn't realize I was doing that.
That's all right.
Well, let me ask you, if there's a nuclear testing method that would have, quote, identified all concerns, close quote, which I presume must mean including this cavern, and he didn't do it, even though he had the city and county inspections and all these other things that you've talked about, that might present a jury issue on negligence, mightn't it? What you're saying is, even accepting that as evidence in the record, which might have prevented a summary judgment on negligence, it doesn't possibly get you to gross negligence.
Close to gross negligence. I mean, the types of cases, as Your Honor referred to, that have found no gross negligence in workers' comp are far more egregious than this. You know, some workers.
Well, let me ask you to address that, because I mean I think I agree with you that if you look at the fellow employee cases, which are the cases for the most part that talk about gross negligence in workers' comp in this context, they set forth a pretty stringent standard that I think we might agree is not met here. Sure. But they're arguing that we should discount that body of case law, that those cases were incorrectly decided, and that a looser gross negligence standard should apply. And under some of the cases outside of this context that talk about gross negligence have language that if you apply that, I think you might have a jury question. You want to address the argument that we should
these cases, if they say they're incorrectly argued, they're over a long period of law. I mean, a long period of time. It's not over 20 years in various contexts. 1990 is one of them, 1993, 1988. I mean, this is over a lot of period of years. There's plenty of time for the Supreme Court to come down with an opinion and say, hey, that's the wrong rule of law, and they never have. And
they can't do that unless there's a conflict or a certified question in the area. Has our court ever addressed the elements of gross negligence in this context?
Your Honor, I don't recall offhand if any of them were decisions of this court. They never alleged as a conflict, so I just really don't recall offhand. If I were the appellant, I would check it and have the answer and rebuttal, but I don't have that. But yeah, they can. The Supreme Court can take jurisdiction when they want. I mean, they can find a conflict or whenever they want to. It's realistically, and they can find there's not one if there is one. But they've had plenty of years to do that and to decide. And this is, like I said, one of those cases. Real quickly, I just saw the Merriman was 88, so that's 24 years they've had, and this has been the law that has been applied over and over. That the Merriman case was one where there was a malfunctioning load switch on the crane, and so that if it was raised too high or at the wrong angle, it would go off, and it was malfunctioning, and it was known as malfunctioning, but as long as you didn't raise it too high, it didn't matter. But they used it, and it fell over and hit somebody, and of course, so that's not gross negligence, that's simple negligence, and that's a lot more flagrant than this.
So in the context of this situation, do I understand you to kind of be arguing, maybe just getting away from the technical descriptions in these cases, but you'd have to have a situation where Mr. Holdorf was actually, someone ran up and told him, that's unstable over there, if you continue, you're going to have a collapse. Is that pretty much what would have to happen here before you would?
Yeah, I believe so, and not only that, to say it, but they know what they're talking about, But yeah, no, I think it has to have gross negligence to avoid workers' comp. They would have to be something like that, because the Supreme Court, the legislature has made clear that they want practically every injury on the job site to come under workers' comp. And, if something like this is just simple negligence, if this were a cause of action, there almost wouldn't be any point in having the workers' comp law. There's nothing anywhere close. Where heavy equipment is driven across this area every day, the GC, did the testing, complied with a county law, which passed the inspection, and they had pumped there 4 times before. Not only the extra 4x4s under the outrigger, but he twisted the thing, and then he pumped for 35 or 45 minutes. We all know there's sinkholes in central Florida. You always detect them. And so there's, what is doubtful is even simple negligence, but it certainly isn't. Some of the other cases, somebody using a drill on a wet pier in water that was improperly spliced, the grounding plug had been removed, and he gets electrocuted. That's not gross negligence. A meat tenderizer that had safety devices and manufacturer warning removed and was supposed to be bolted down and that's not. Explosion on Miami Vice. They're just all the cases which hold there is no gross negligence are much more egregious. And as far as the summary judgment hearing, we put the transcript of both the motion for protective order and the transcript of the summary judgment hearing 3 weeks later. The actual facts, time the motion for summary judgment was filed on March 18. The motion for protective order was heard on April 12th, which was 3.5 weeks later, and the summary judgment hearing was May 2nd, which was 3 weeks after that. And the judge at the hearing had said, go ahead. He said there's no deposition set, no discovery set. He's just saying that he don't want it entered. And both the court and the defense attorney gave the attorney the out if he had legitimate discovery to go forward. The hearing that I have in my brief, and this is a quote from my brief where I summarize the thing. On page 10, the court said the plaintiff should go ahead and try to get the depositions as quickly as he could, and that if there was any material the plaintiff needed within the time, he could gather affidavits that might apply to the motion for summary judgment. And then counsel of the defense said that it was willing to move the trial date, remove it from the docket, and then the summary judgment could be accommodated at a later date. So, he was given the out, but instead of doing anything, 6 weeks after the motion for summary judgment was filed, he still hadn't set a deposition, hadn't pointed, in the hearing. He didn't say, Judge, we need the deposition of this person, which we think will show this, or we need that. He didn't say we need the deposition of anybody, much less that what information. And I agree with what Your Honor said, is that the judge, when he doesn't follow the rule, the judge isn't required to just let the case go on forever. He had ample opportunity, and he didn't cite to anything that he needed, and he didn't set it. He had 6 weeks to set it. So I think that the trial judge ruled correctly, and there's just no point in prolonging the litigation. That under the facts he showed, they're just is doubtful, simple negligence, and certainly not gross negligence. Thank you very much, Your Honors.
Thank you, sir.
May I please the court?
Yes, ma'am.
I just wanted to touch on some of the issues that Mr. Sherman raised. First of all, simple negligence was conceded by defense counsel at the hearing. That's not an issue. That has never been an issue, whether or not these actions rose to the level of simple negligence.
Well, they conceded there was an issue. They wouldn't be entitled to summary judgment on that. They didn't concede they were negligent.
They didn't concede that there was gross negligence, but the defense attorney did concede that there was simple negligence.
Really?
Yes, and if you look to the transcript, you can see in several instances in which he says that. Also, with respect to whether the summary judgment statute 1.520 subsection F was followed, that was not brought up by Judge Rodriguez. It was not brought up by the defense or the appellee. It was never an issue. There was a gentleman's agreement that the motion for summary judgment was going to be rescheduled, and that didn't happen. With respect to Mr. Sherman talking about the manuals are for a very specific purpose to put people on notice of a dangerous condition. If we shouldn't read them, then why have them in the first place? We're talking about a huge concrete truck, very extensive, complicated piece of machinery that requires a very extensive manual. And it's reasonable that a person should read it, and it's reasonable that a person should adhere to it. In the context of this type of dangerous activity, it's gross negligence for not following what was set forth in that manual. There was also a dispute in the facts as to how long the actual concrete had been poured. HERON Gutierrez said it was about 5 minutes. Mr. Holdorf said it was about 45 minutes. That is a dispute in the facts. That goes to whether or not the jury should decide that issue. Therefore, summary judgment was premature in this case. If you look at the 50 DCA cases that we did cite, we cited to Anderson versus Wolf. That had to deal with summary judgment, as well as the Arguelles case. That is also a 50 DCA case. And it basically says that it's reversible error to enter summary judgment when relevant discovery was in process. And if you also look to the Arguelles case, it basically says the same thing. And I'm out of time, so thank you, Your Honor.
Thank you both.
Thank you.
Have a safe trip home, and that will conclude our oral argument session for the morning.